PILPG, of which you are a member of its team, is currently providing legal assistance to the National Council of the Union of Burma on the use of legal mechanisms to challenge the legitimacy of the present government in Myanmar, and is in the forefront of the resistance movement against the military junta. That is the NCUB. Now, bearing in mind all that, do you agree that however much it might be right or even laudable to be associated with those bodies, it might appear to a reasonable disinterested observer that you have, to use an American phrase, a dog in the fight?
No, sir, I don't, because the nature of each of those, and I can recite what they are if you want. I think the Holocaust Memorial Museum project, I was one of the military experts in a project asked to assess how militaries should train and how militaries should prepare to counter genocide. The Albright-Cohen Commission was sponsored, I don't know, 17 or 18 years ago. I served on that, and I've had nothing to do with the Holocaust Museum since. The Justice Rapid Response, I didn't know that they had done anything there until I saw it in your filings. They keep an experts roster of over 700 experts. They raise money. They send particular experts to particular places. I'm on their roster and I've never done anything for them ever. Public International Law and Policy Group, I did some work for them in Uganda probably 18 years ago, maybe. I don't know, and I know some of the people that are there, but in no way is my analysis affected by any of those associations or by any of that work, some of which I wasn't even aware of until I saw that in pleadings.
Right.
So no, sir, these are my statements, my opinions, completely independent and impartial.
Right. And throughout your reports, you don't consider, or I say discuss, at all any other possible conclusions to what you read in the FFM reports.
Sir, the totality of the modus operandi, which was systematic, which was directly contravening all of the rules of engagement, and it was interesting to me in the memorial, this is very telling, or the counter memorial, I'm sorry, that when I made the statement in the first paragraph 22 of my first statement, I said words to the effect of that Tatmadaw commanders in no way can plead ignorance. They have to know that this is modern doctrine of counterinsurgency. When I saw the counter memorial, I saw rules of engagement that largely reflected those norms. Those rules of engagement absolutely are valid counterinsurgency norms that were crafted in the particularity of this context for ARSA and the Arakan Army. So that told me they do understand those norms. They published rules of engagement. They disseminated them to troops, because there's an annex in your work of how many thousands of copies you printed and disseminated. Then, with respect to this portion of the population, they engaged in that sustained modus operandi from start to finish, which not only was not compliant with those rules of engagement on an aberrational basis, it simply ignored that they existed with two full divisions, pre-planning, coordination. And I'll give you the modus operandi again, which to me is absolutely indicative of an intentional, coordinated series of attacks directed against that portion of the population. Surprise attacks on civilian villages with no notice, with no warning, surprise attacks, often from multiple angles. Indiscriminate shooting from the get-go, no effort whatsoever to determine an ARSA location or an ARSA house or a safe house or an IED factory, none whatsoever. No efforts to do a cordon and search where you would cordon an area and then search for the particular insurgent activity or thing you're looking for, followed by segregations and executions, often in a gruesome way, followed by mass extermination, all at various places. I say it followed by, it's all happening at once in chaos. But it's the same pattern over and over and over, directed against that group of people. Extermination, shooting at refugees, followed by mass rapes, orchestrated all over the place. In every instance that I read had some elements of rape. There is no military necessity ever for rape. There is no military necessity ever to launch indiscriminate attacks against a civilian population with no notice, etc., followed by the burnings, of course, and the bulldozings. That entire pattern replicates itself in over 54 documented instances, and that's the basis of my opinion, sir.
Well, thank you, Mr. President.
I thank Mr. Hopper. I now give the floor to counsel for the Gambia, Mr. Reichler, in the event they wish to re-examine Mr. Newton.
Thank you very much, Mr. President. Just a few questions. Professor Newton, you were asked whether you considered that there were any other alternative explanations for the Tatmadaws' conduct, and any alternatives to the conclusion that you reached, that these clearance operations were conducted with the intent to destroy the Rohingya population. Did you consider whether this was simply a disproportionate use of force by the Tatmadaw?
I absolutely did, sir, because that was some things that I saw in some of the filings of this was just a random incident, this was just a renegade soldier, etc. And that can happen. And some of those things on the periphery might have been one soldier, renegade, etc. But the overall pattern of conduct in no way can be properly characterized, in my opinion, as a just indiscriminate use. The pattern, the consistency, the planning, the utter ignorance, the fact that there were COIN-compliant rules of engagement in place, which were completely ignored across the area, across the region, through an extended period. These were not just one days. The trick for me intellectually to an indiscriminate incident is that the rules of engagement are followed and then there's an occasional aberration. Here, there were rules of engagement in place that were completely ignored and subordinated to a deliberate pattern. So no, sir, I believe it was as I stated.
Could this have been another alternative explanation? Could this have been ethnic cleansing?
Based on the facts as I saw them in the FFM, in those at least 54 up to 76 incidents, my opinion is that it is not ethnic cleansing based on the pattern of practice, the mass rapes, the fact that it's documented in multiple witness statements that while those rapes are occurring, they're racist, they're insults, they're ethnic slurs against that, the fact that babies are killed. Some babies are thrown into burning houses, others are thrown into wells, others are thrown into the river. Ethnic cleansing does not involve killing the children of a particular group. The fact that men were slaughtered sometimes when they were hung, and the fact that you're shooting at fleeing refugees. If ethnic cleansing is your goal, you don't keep shooting. You don't put troops on the river as people are fleeing into Bangladesh and sink boats as they're about to get into Bangladesh. And there are others. But the totality of the pattern, sir, says to me this is not just ethnic cleansing.
You, on cross-examination, you expressed the opinion several times that these clearance operations or these modus operandi were pre-planned. What's the basis for your opinion that these actions, which you characterize as their modus operandi in 54 or more places, were pre-planned?
So I think they were pre-planned both at a macro and a micro level. At the micro level, which I partially addressed, you had multiple units convening on a particular place. You had logistics coordination. There's an example, for example, where you have extra petrol being flown in, you have extra ammunition, so you had logistical support, which required planning. You had people of multiple commands. And so lots of examples on the micro level of coordinated attacks, rendezvous points, et cetera, et cetera, et cetera. On the macro level, after the 2016 events, very clearly rising tensions, very clearly based on the reporting at the time, rising tensions between the various communities, 2 pre-staged light infantry divisions, who, when the signal was released from higher headquarters, went in and performed, as I said, the sustained modus operandi. That takes planning. It takes, here's what we're going to do when we get to this place, 1, 2, 3, 4, 5, 6. And a disciplined military force does that. To me, it's a military impossibility that that pattern of conduct, consistently replicated across so many places by so many different units, could have been merely coincidence. It was pre-planned, it was orchestrated. To the best of my ability, that's the way I see the evidence from the FFM.
Counsel asked you if you knew that a certain number of attackers attacked a particular village. And he himself referred to documents that they have submitted to the court. These documents consist of military reports, that is, reports from field officers who were reporting on the events surrounding these alleged ARSA attacks to their superiors. Do you have any opinion on the reliability of such reports and the information contained in those reports, number of attackers, number of terrorists killed, etc.?
Sir, in my extensive experience, and I can give you some concrete examples from around the world, military reporting that comes up within a chain of command is both unreliable, absolutely unreliable. I attach no evidentiary weight to such self-reporting through a chain of command, and self-serving. I say unreliable because I have never seen a military report that says the following: we just ignored the rules of engagement and did the following things. We just committed war crimes and did the following things. People from subordinate ranks don't self-report. And furthermore, in my professional opinion, they don't want to hear that at the superior level. So that's the system. They're totally unreliable, especially with regard to numbers. And that's the self-serving part. I inflicted X amount of damage. We've had body count inflation since Vietnam, and it's very common. So those reports, in my view, have no evidentiary weight, unless they're accompanied by independent external examinations and actual corroboration of, in whatever form, whether it's imagery or whatever. They're unreliable and self-serving, and that's true for all armies. It's not just true for the Tatmadaw. I'll give you an example from U.S. practice. In the Haditha massacre in Iraq, a Marine unit murdered 24 Iraqis and committed some rapes on the margins. They sent back a perfectly fine patrol report. Perfectly fine, great patrol. 3 other groups of Marines subsequently went into the same place. Here's a village. They've just suffered this incredible trauma. 3 other groups of Marines on 3 different other things went in for particular purposes, sent back their reports. Mighty fine patrol, we killed some insurgents today. When the battalion commander of that unit heard rumors that something had happened, his immediate first response, instinctive, was, my Marines would never do that. It took many years of subsequent investigations, independent investigations, command inquiries, to actually get the truth of what happened in Haditha, and which, of course, led to prosecutions. So no, sir, I don't believe that military reporting straight up through command channels has any evidentiary weight at all unless it's corroborated.
Thank you, Professor Newton. Mr. President, I have no further questions.
I thank Mr. Reichler for re-examination. I thank you, Mr. Newton. Certain judges wish to put questions to you. And please respond to each judge's question after it is put to you. When you have finished, I will call on the next judge who wishes to put the question. So I start with the Vice President. You have the floor. Madam.
Good afternoon, Professor Newton.
Yes, ma'am.
I have a couple of questions for you. First, I'd like to know what were your terms of reference before you commenced your first report?
Thank you, Madam Vice President. Terms of reference is a formal form which implies a contract and a set of deal. I never had such arrangement. I received a phone call inquiring, did I know much about this issue? And the answer was yes, in terms of the substance of it. And was I interested in assessing this set of facts in that particular situation against established counterinsurgency doctrine? I found that to be interesting, I found it to be relevant, and that's why I accepted it. But in terms of reference, that's all that was. Look at this pattern of attacks as documented in the FFM and give us your opinion about the validity of those attacks as military practice.
What prompted your second report? Were they different terms of reference, or what exactly prompted your second report?
No, ma'am, there were no separate, quote, terms of reference. Again, it's much more as a phone call. The second report was primarily prompted by the wealth of material that I learned in counter-memorial materials. I had never seen rules of engagement. I had never seen many details provided by Myanmar in its reply, and that was interesting to me because it exactly validated my core premise. When I wrote in 2020 that, I think paragraph 22, I didn't think there was any way that they could plausibly plead ignorance. When I saw the counter-memorial materials, it validated that instinct, which is why I then wrote in the second statement more detail about the rules of engagement and how I saw the fact that they did know current practice. They did know how to do counterinsurgency properly in accordance with the law. They did publish rules of engagement that were compliant, which they completely ignored, and they ignored it with respect to this group, this area, this set of villages, up to 76, if you want to use the big number. So there were no separate terms of reference, ma'am.
Also, you have stated before us that you had no fact-finding ability of your own, so you depended entirely on the findings in other reports, in particular the UN FFM report. Is that correct?
Yes, ma'am.
So that means that you took these reports and based on their opinions and findings, you drew your own conclusions as well.
I don't know about opinions and findings, ma'am. I did a fact-based analysis. The first thing I did when I downloaded the full FFM report was read through their methodology, where they talk about corroboration, they talk about independent sources, they talk about the objective corroboration in the form of imagery and medical personnel. I don't know how to do that. I'm glad somebody does. The corroboration, the system. Then I carefully read the report. I was careful not to just adopt their opinions. In fact, there's some things in there that I quite disagreed with. But that's not my job. My job is to assess that factual basis across the entire campaign. I say job, my task. So no, I didn't adopt their opinions or their conclusions or anything. I made my own independent factual analysis of the sources of corroboration to the best as I could find and my knowledge of military operations. In the second report, informed by a great wealth of material that came in the form of annexes. So it was a bit more informed. There were some things that I knew early on or suspected that became clarified, and that was the process, ma'am.
But can I just ascertain that you yourself did not speak to any witnesses referred to in these reports?
That is correct, ma'am.
Thank you. Thank you, Mr. President.
I thank the Vice President for the question. I next call on Judge Note.
Thank you, Mr. President, and thank you, Professor Newton. I have a question. At some point, you said that what happened in Myanmar reminded you of a genocide in Iraq. and I did not understand acoustically which genocide in Iraq you were referring to. Thank you.
Thank you for the question, Judge, and I'm sorry, I have a terrible accent. I was one of the people that worked on the prosecution case in the Anfal genocide, which was Saddam's sustained campaign in northern Iraq directed against the Kurds, which took place in the context of the Iran-Iraq war. And what struck me in the FFM report, just that little detail of bulldozers showing up. It's not enough to drive a people out. It's not enough to destroy their way of life. It's not enough to murder them. Now we have to burn their villages, which happened, and bulldoze them under the ground. That happened in northern Iraq. And one of the, well, I say one, hundreds of evidentiary satellite images in that particular case were exactly those before and after photos. So when I saw some of the before and after photos in the FFM, that was what was immediately triggered.
Thank you, Mr. President.
I thank Judge Nolte for the question. I next call on Judge Cleveland to put her question.
Thank you, President, and thank you, and good afternoon, Professor Newton. My question is simply a point of clarification. Your witness statement and expert reports set forth what you describe as the distinguishing features of counterterrorism and counterinsurgency operations. We've had some discussion today of best practices. With respect to the relevant international law governing such operations, you reference international humanitarian law, international human rights law, and international criminal law. Is it a correct conclusion from your reports that the use of military force for purposes of counterterrorism or counterinsurgency must satisfy, among others, the requirements of international humanitarian law? In other words, it requires the presence of an armed conflict with a qualifying non-state armed group and compliance with the international law rules regarding conduct of hostilities, including the principles of distinction, proportionality, and precaution. Do you agree with that? Thank you, Mr. President. Well, thank you.
I agree in the macro, ma'am, except that I'm trying to think of examples where an easy example maybe from this record would have been much more debate before August 25th, 2017 about whether the ARSA group had risen to the level of organization, the level of intensity, the level of sophistication, the command structures, all the basic criteria. And yet, I totally believe that the government had, before they met that threshold, an absolute sovereign right to act against lawbreakers, particularly in that situation in a very tense ethnic conflict where you had roving bands from one ethnicity targeting another, and this was a continuing problem. I fully believe that the government had the right to intervene in that situation to try to alleviate tensions. That right was based on the fact that there was law breaking and ethnic violence on their territory not without regard to the clear categorization that later became obvious, unmistakably obvious, whether they had actually met the threshold to be an armed conflict not of an international character. So I think I heard it correctly, the way you framed it, ma'am, that it's a necessary prerequisite. I would not agree with that. I think the government has an absolute sovereign right to intervene with lawbreakers and brigands and restore law, legitimate government authority. But they must do it at all times in accordance with the relevant applicable law, focusing on the problem, not the entirety of the civilian population.
So I guess my follow-up question would be, prior to the existence of an international or a non-international armed conflict, what would you say was the relevant body of international law applicable to Myanmar's response to this problem?
On a purely international level. Obviously, genocide law, which is applicable in times of peace and war. Crimes against humanity law, applicable in times of peace and times of war. Various strands of human rights law, And to the extent that international principles are embedded in domestic law, I would accept those as binding sources of international law. They just happen to be reflected in domestic practices. I'm trying to think if I'm missing something. There may be some other particular treaty obligations applicable in a particular setting, but absolutely, genocide law is relevant at all stages of that.
Thank you, Professor Newton, and thank you, Mr. President.
I thank Judge Cleveland for her question, and I now give the floor to Judge Tladi for his question.
Thank you very much, Mr. President. And my question will follow on, I think, from Judge Cleveland's question. One of the issues of dispute between the parties concerns the relative strength, organization, character, nature of ARSA. And this raises for me the question of whether or not counterinsurgency, best practice, is dependent upon any of those factors. Now, I've looked at your first report, paragraph 9, and there you say insurgency is a complex and context-dependent phenomena. The details of particular coin operations vary depending on the idiosyncrasies of the affected population, the terrain, and the characteristic of the state seeking to reassert its sovereignty. But nowhere there, and I haven't seen it anywhere else in any of your reports, is the nature, character, strength of the insurgent a relevant factor. And I'd like to know whether that's a relevant factor or not. Thank you.
I think it certainly is a relevant factor. I'm not sure what you mean by relevant factor to relevant as opposed, with respect to what's characteristic. But I think nature and strength of the organization is always a relevant factor to stick to counterinsurgency, because one of the core tasks of a government that wishes to seek law, public safety, is to dry up the sources of recruiting. Every insurgent group, however large or small, has some grievance. They have some motivating factor. They have something that they use to recruit. And it varies, as I say, across the world, lots of different things. The government always, and this is not dependent on the side, those are common factors, has the ability to deter recruiting. And a very simple example from this case. In August of 2017, there was a particular village in northern Rakhine province, in the province, that was completely surrounded by Rakhine villagers. They called it the blockade. And ARSA leaders publicly said, please help us, because our people are stuck inside. They can't get out the blockade with armed Rohingya, or armed Rakhine, I'm sorry. We can't collect food. We can't use the bathroom. We can't collect firewood because the perimeter of our camp, very simple thing to go in. And I think that would have had a direct impact on, for example, undermining ARSA recruiting. That the government was making, this is why the ICG called it a situation of hopelessness and despair. So numbers is always relevant to me in terms of recruiting. And the larger numbers grow, of course, that leads to organization, which leads to greater capacities, which leads to greater effectiveness, which does over time increase the level of violence, moving towards the necessary threshold of intensity to legitimately be termed an armed conflict not of an international character. And there's an extensive section in the FFM report that analyzes that with respect to ARSA. And debatable, it's, I think, more likely that they would have qualified in October 2016, but after August 2017, there's no question at all.
Let me make the question a little more specific. Recruitment is one thing as a tactic, but I guess my question is, if the level of organization of ARSA and the risk that it poses to the state is of a particularly high level, would that justify a greater use of force? I mean, that's really the question that I'm asking. That's the relevance in terms of counterinsurgency that I was thinking about. Thank you.
No, sir. Counterinsurgency doctrine is always aimed at the destruction of the group. It is never aimed at the destruction of the civilian population. And if you look at the rules of engagement, which were crafted specifically for ARSA, they're totally compliant, in my view, with absolute best practices in COIN universal standards applied around the world. The point I want to say, and with respect to your question, though, is that they're malleable. They're one size fits all. Those rules of engagement fit from a very small insurgency of 20 people all the way up to a giant insurgency that has large weapons and ammunition, etc. The rules of engagement, the principles of counterinsurgency, are not dependent on the size of the group or their capacity. That is the basic way to conduct, as I call them, authentic counterinsurgency operations. There's very clear distinction between the entirety of the civilian population and the group or the interests or the funds or whatever thing you're trying to restore legitimate state authority over.
I give the floor next to Judge Brandt.
Thank you, Mr. President. Thank you, Professor Newton. I would like to ask you to raise a question. In your opinion, in order to define a pattern of conduct, as you tried to establish, do you think it's relevant to determine the number of civil casualties?
The number of civilians killed?
Yes.
On which side? The victims of the insurgents?
Yes,
or
the victims.
The victims of the insurgents?
Yes, for the victims. Is that relevant in order to provide, in order to establish the pattern of conduct?
I don't think so, sir. I mean, there is...
Mr. President, it seems to me the witness restated the question in a way that indicated he possibly did not understand.